The Trump administration's proposed mass deportation policies have been met with immediate and significant resistance from the U.S. federal court system. These plans, which aim to broaden and expedite the removal of millions of immigrants, have been challenged on fundamental constitutional and legal grounds, primarily focusing on violations of due process. Federal judges across the country have issued temporary restraining orders and injunctions, effectively pausing key components of the administration's strategy, including the expanded use of expedited removal and the denial of bond hearings to certain immigrants. This legal battle is shaping up to be a defining conflict over the separation of powers and the constitutional rights afforded to all people within the United States. Analysis, reasons, and consequences. The core of the legal opposition is rooted in the principle of due process, as guaranteed by the Fifth Amendment to the Constitution. Due process ensures that no person can be deprived of their life, liberty, or property without fair legal proceedings and safeguards. Immigration rights groups and the American Civil Liberties Union, ACLU, argue that the administration's policies, such as the expansion of expedited removal to long-term residents, strip individuals of their right to a fair hearing before an immigration judge. Historically, expedited removal was limited to migrants apprehended within 100 miles of the border who had been in the U.S. for less than 14 days. The new policy, however, attempts to apply this skimpy process to millions of people residing in the country's interior, many of whom have lived here for years or decades. Judge Giacob, in a recent ruling, articulated this concern by stating the government's argument that undocumented immigrants are entitled to no process is truly startling and risks eroding constitutional protections for everyone. Another key legal challenge focuses on the administration's new policy of mandatory detention without bond for immigrants who entered the country without inspection, regardless of how long they have lived in the U.S. For decades, these individuals have had the right to request a bond hearing before a judge while their cases proceeded. The administration's revised interpretation of the Immigration and Nationality Act, INA, seeks to eliminate this right. Opponents argue that this change is an unlawful departure from long-standing precedent and, as a class action lawsuit filed in Colorado contends, violates due process by locking people up for extended periods with no justification or chance for release. This shift, critics argue, is designed to coerce individuals into accepting deportation rather than fighting their cases in court. Furthermore, the administration's invocation of the obscure Alien Enemies Act of 1798 has drawn intense scrutiny. While the law allows the president to detain or remove alien enemies during a declared war or in the event of an invasion, its application to civilians in a non-wartime context is highly controversial. Critics contend that this use of a centuries-old wartime measure is a dangerous overreach of executive power, bypassing modern legal and constitutional frameworks. This legal strategy has been temporarily blocked by federal courts, which are likely to examine whether the administration can justify a finding of invasion in the absence of a congressional declaration of war. The judiciary, in this context, is acting as a crucial check on the executive branch, preventing policies that could lead to mass, unjustified deportations and indefinite detention. Predictions and solutions. The future of these policies will likely be determined by the Supreme Court. The administration has a pattern of appealing lower court injunctions to the High Court, where it has had mixed success in the past. While the Supreme Court has shown some deference to the executive branch on immigration matters, it has also rejected certain unilateral actions, such as the 2020 attempt to end the DACA program. The key question will be whether the court views the new policies as a legitimate exercise of executive authority or an unconstitutional violation of due process rights. The rulings from lower federal courts, which have consistently sided with immigrant rights groups, suggest a strong legal basis for continued challenges. In the face of these ongoing legal battles, a lasting solution requires action beyond the courtroom. For the administration, a potential path forward would involve crafting policies that, while still strict, are designed to withstand judicial scrutiny by adhering to constitutional principles. This could mean establishing clearer, more consistent legal procedures that include avenues for appeal and judicial review, rather than attempting to circumvent them. For immigrant advocates, the legal strategy of challenging due process violations will likely continue to be the most effective tool. However, a more permanent solution would require legislative action from Congress. The current reliance on the judiciary to shape immigration policy highlights the political gridlock that has prevented comprehensive immigration reform for years. Until Congress acts to create a stable, coherent, and constitutionally sound immigration system, the courts will remain the primary battleground, and the fate of millions of people will hang in the balance of ongoing litigation.